Good day, everyone. I'm Faith Uma, and I'm here again to share with us some insights around our businesses and all that we do. Today, we're going to be discussing, or I'm going to be sharing with you on a very salient topic or salient subject of which clients over the years have always wanted more insight about, and that's the subject around registration of patents, trademarks, designs, and all of that. Every business, every organization, including individuals, at one point in time will always have a form of intellectual property that they wish to register or they wish to protect. And the process of doing all of these things are the things we'll be treating on in this episode. All right, let's go straight to the point. First, what is trademark? What is patent? Let's start with patent. What is a patent? A patent is, simply put, it's an intellectual property right accrued to a particular invention or innovation, as the case may be. Now, it's not just anything that is invented that can be patented. It's not any innovation or any invention that actually can be patented. So the striking factor there or importance is it must be a novel invention. By novel, I mean it must be new. It must be an invention that has never been, or a solution that has never been, so that you have somebody that is very talented at home and that is very skillful in creating things. Whatever it is that that person is creating or has invented, of which we have been seeing so much of a lot of inventions from our young ones these days. Before that invention can be patented or qualifies to be patented, it has to be something that is novel, that has not been there. Even if it has been there, it has to be an improved version of whatever it is that has been there before. So let's take note of that. That's the only time it can fly for being patented. Now, also, what is a trademark? It's also an intellectual property right accrued to a name or a symbol, or what we all know as a logo. All right. So definitely every business now has one form or the other has a logo representing his or her business. All right. Every organization has that as well too. So most times, if you find out that your brand is becoming very well known, your brand is becoming a household name, or your brand, or you foresee your brand becoming an international brand, it is absolutely proper, and you'll be on the right track to ensure that it is actually trademarked, so that it can well be protected and then not be in use by others. So we already have an oversight understanding, all right, of what a patent and what a trademark is. Now, it's also important for us to know who are the people or which regulatory body is in charge of registering trademarks and registering patents. So we have the Ministry of Industry, all right, Ministry of Industry, Trade and Investment. They are in charge of registering trademark and patent under the Commercial Law Department. So we have that form or that part of the government being in charge of everything that has to do with your patent and trademark registration. Now, what is the process of registering a trademark? All right. So let's say we have a trademark, we have a mark for your particular product or for your particular service that you want to register. You want it to be exclusive to you alone and to no other. All right. So what are the processes? So first and foremost, you must be able to get an authorized agent, of course, who is registered with the ministry to be able to carry out that trademark process for you. So not every or not any or random person can just carry out a trademark registration for you. You have to be sure that whoever it is that is handling it for you is an authorized agent registered with the ministry. All right, and we have a lot of them out there. Okay, so once you get this authorized agent, you are going to endorse an authorized agent form, giving the person that mandate to be able to apply for such trademark registration on your behalf as the applicant. Once that is done and that is settled, next thing is to ensure we carry out a preliminary search. So what does the search entail? It entails finding out if there is a similar name or that same name existing in the database of the ministry, so there will be no conflicts of names. So that name you want to register or that sign you want to register, the preliminary search will help us check if there is somebody else using that name or there is somebody else using that trademark. All right. If your preliminary search comes out successful, then the agent can go ahead to make the application, all right, to the department. And once the application is made, once the application is filed, all right, the next thing is an acknowledgement letter will be sent to you almost immediately. And afterwards, what we call an acceptance letter. So once your acceptance letter is given to you or is brought in by your agent, you know you're halfway there. But now for every application, or for every acceptance letter that you get on your trademark or on your application, it will have to go through what we call Nigerian Trademarks Journal. So that journal, it's published there for a period of 2 months for any opposition, if there is any. So the idea is we are making this public, that this name or this brand is supposed to be published. And so if there's anybody that has a contrary view as to why this should not be trademarked, let them come in. But within that 2 months, if there is no opposition, then you're good to go. Apply for your certificate, and the registrar will definitely hand you over your trademark certificate, and then that particular mark of yours will be officially trademarked and becomes an intellectual property of which you have rights over, or exclusive rights over. Now quickly we're going to go into the subject of patent and the process flow. It's similar to the same thing that's similar to trademark. All you have to do again is also you get your agent and also do your preliminary search, and then once the search is confirmed and you're good to go, you file your application. Your acknowledgement letter is sent, and then you file what we refer to as a claim. A claim is a document that in details, okay, spells out every segment of your innovation and inventions, down to every bit of details, explaining all of the different segments or whatever it is your invention is all about, how from the scratch, the ideation stage, up to how you've come up with your MVP or whatever it is that you have come up with, okay, that is that invention. You're going to have everything explained out in the claims, and that is what you're eventually going to file, all right, to the registry. And then upon their publication in the journal as well, once we're good to go, then your patent certificate will also be given to you as well. So it's a similar process. Another important thing that we must come to understand is there's all of these things, the patent and the trademarks have their validity period. All right, for the trademarks, it's valid for the first 7 years, and then afterwards, all right, it is indefinitely renewable for a period of 14 years. But then for the patent, it has, okay, a first validity period of 20 years. At the end of 20 years, that patent elapses. So you're bound to always check, all right, the validity period of your trademark or patent and ensure it still falls within time. And where it's about to get to the point of elapse, your agent should quickly carry out the processes of renewal. So that's very important, and that's something to take note of. Also, why do we have to trademark, or why do we have to patent whatever it is that is intellectual property? It's important because it makes it exclusive to you alone, so no other can be able to use it. Where another person uses, or what we call infringes, on that intellectual property right of which you've gotten on your trademark or your patent, you have the right to sue, you have the right to demand for claims on certain damages from such person or organization. All right, and also there is also an important thing to note on the importance of trademarking or patenting whatever it is that is your intellectual property. If you do that, it gives it an asset nature, especially for patents, because when you have a patent over an invention, it makes it an asset to you in the sense that you can also begin to give out licenses or license rights to people, of which can bring in revenue for you as well too. So you can give people licenses to create or go ahead to produce your inventions, but not without the express permission from you, of course, and not without some cases royalties or licenses fees that will be accrued to you. So it's a revenue stream as well too. So that's why it's very important to ensure that your patents and your trademarks are officially registered. Another thing to note is, especially for patents, also for trademarks, when you invent a particular thing, all right, and you have not gone ahead to file in the registry, if somebody else invents after you, or even copies whatever it is, or have access to that innovation or that invention and goes ahead before you to go and file at the registry, by law, all right, by principle, it is believed that that person is actually the first person to have invented that particular invention, and the rights will actually be given to that person. So it's very critical and very important for you to quickly and be on time in registering your invention, so that you don't lose out on that right of being the first person to have invented that. So these are things and key notes that every one of us should take cognizance of and ensure we make the most of it. Thank you very much. I'm sure you've learned one or two things around trademarks and patents, and I know you will have to get the right attorneys that are into IP, that's intellectual property, trademarks or patent, to be able to do justice to your innovations. Thank you for listening, and see you next time.